Welcome back to Lawyer Stories. Today, we're delving into a case that highlights the importance of contractual good faith, especially in the context of personal services, and how clear evidence can unravel even the most elaborate deceptions. Our consulting company was recently approached by a law firm representing a client, Ms. Reynolds, who found herself in a deeply frustrating situation just hours before her wedding day. Miss Reynolds had planned her wedding meticulously, and a critical component was securing a top-tier hair and makeup artist. In March of this year, she entered into a signed contract with Thorne Bridal Services, operated by an artist we'll call Miss Thorne. This contract was to provide comprehensive hair and makeup services for herself, her family, and her bridesmaids for her September wedding. The total cost for these premium services was $2,500, paid in full 2 weeks prior to the event. Interestingly, back in April, Miss Thorne contacted Miss Reynolds, ostensibly to clarify some timeline details. Ms. Reynolds directly asked if there were any issues with her booking, thinking it was unusually early for such specifics. Miss Thorne unequivocally assured her there were none. Miss Reynolds thankfully documented this conversation with a screenshot, a detail that would later become particularly telling. The situation took a dramatic turn at noon on the day before Miss Reynolds' wedding. Miss Thorne called to cancel, citing an urgent emergency surgery requiring immediate bed rest. She informed Miss Reynolds that a replacement artist would be sent. However, the replacement was not of Miss Thorne's caliber, suitable perhaps for bridesmaids, but not for the intricate bridal work Miss Reynolds had paid a premium for. When Miss Reynolds attempted to discuss this, Miss Thorne reacted with a furious outburst, accusing her of showing attitude and reiterating her need for bed rest. This distressing exchange was also captured by Miss Reynolds through video evidence. On her wedding day, the replacement artist performed the services. However, as Miss Reynolds later confirmed, she was profoundly dissatisfied. The artist couldn't achieve the desired look, leading Miss Reynolds to spend an additional 2 hours redoing her hair and makeup herself. This unfortunate delay disrupted her meticulously planned schedule on what should have been a joyous morning. The true extent of Miss Thorne's deception came to light shortly after the wedding. Miss Reynolds discovered a social media post featuring another bride, whose wedding took place on the very same day as hers. Miss Thorne was tagged in the post. Sensing a discrepancy, Miss Reynolds contacted this other bride directly. The bride confirmed Miss Thorne was indeed on site and personally performed her makeup that day, when Thorne claimed to be on bed rest. Further investigation revealed Miss Reynolds had booked Thorne on March 24th, while the other bride's booking was April 11th. This suggested Thorne accepted the second booking, knowing it conflicted with her prior commitment. From a legal standpoint, Miss Reynolds' case, under New Jersey and New York jurisdiction, presents several compelling arguments. At its core, this is a clear breach of contract. Miss Reynolds contracted for Miss Thorne's specific expertise and quality, evidenced by the premium rate and an introductory email promising high customer service. The replacement artist demonstrably failed to deliver that standard, causing dissatisfaction and delays. The contract itself contains a failure to perform services clause. It states that if the provider cannot perform, they must give notice, issue a refund or credit, and excuse the client of further obligations. While a replacement was sent, the key question becomes whether this replacement truly fulfilled the contracted service asterisk and whether Miss Thorne acted in good faith. This is where the implied covenant of good faith and fair dealing recognized in New Jersey becomes paramount. This covenant is an unwritten, legally binding agreement that parties act honestly and fairly. Miss Thorne's behavior, including false statements about surgery, working for another client, and raising her voice at Miss Reynolds, clearly demonstrates unprofessional conduct. She deliberately misled Miss Reynolds, creating a false premise for a substitute. Thorne then failed to ensure the substitute met agreed quality. Her booking Ms. Reynolds in March, taking a conflicting April booking and falsely reassuring her, suggests premeditation and prioritizing the second client. Regarding damages, Miss Reynolds paid $2,500. While Miss Thorne may argue a replacement fulfilled the contract, the service was substandard and didn't align with the premium rate. Miss Reynolds is entitled to the difference in value. Quantifying this difference is challenging, but dissatisfaction, redoing the work, and a 2-hour delay contribute to loss of value. Given Thorne's deliberate deception and bad faith, there's a strong argument for recovering the full $2,500. The court could view Thorne's actions as a material breach, voiding the substitute's performance, or award damages reflecting the full harm caused by deceit, beyond just service quality difference. Our immediate advice to Miss Reynolds and her legal representatives is to send a formal, detailed demand letter to Thorne Bridal Services. This letter should explicitly outline the breach of contract. It must highlight Miss Thorne's deliberate misrepresentation, her working for another client, the substandard replacement, and wedding day disruptions. It should demand a full $2,500 refund, citing breach of contract and good faith violation. Should Thorne Bridal Services refuse a refund, Miss Reynolds has a robust case for small claims court. Her evidence is compelling: the signed contract and the April screenshot proving Miss Thorne's false assurance. Further evidence includes the video of Miss Thorne's aggressive response, the social media post, and the other bride's direct confirmation combined with the booking timeline. This refutes Thorne's fabricated emergency and establishes intentional deceit. We anticipate Ms. Thorne's defense would rest on arguing a replacement was sent per the failure to perform services clause and the provider fulfilled its obligation. She might also downplay quality difference or deny fraudulent intent. However, a New Jersey or New York judge, faced with Ms. Reynolds' evidence, especially the deliberate lie and booking timing, would likely find Thorne's actions in bad faith and a material breach. The court is unlikely to look kindly on a professional lying for a wedding, then delivering substandard service. Emotional distress, while not a standalone claim, would contribute to the court's perception of the severity of Miss Thorne's actions. In conclusion, Miss Reynolds has a strong legal position. The goal is to recover the full amount paid, not just a marginal difference in service value, given the proven deceit and bad faith. This case reminds us that while contracts outline obligations, good faith and honest dealing are fundamental pillars of any commercial agreement, especially for personal and significant events. Miss Reynolds should confidently pursue her claim.